Good morning, good afternoon, good evening. Thank you to all of you who are here. It's very nice to have you all here. Thank you especially to our panelists. I think this is going to be a really fascinating discussion, and I'm really looking forward to it. Welcome to the second annual GNHRE-UNEP Summer-Winter School for Human Rights and the Environment. We are, this year, as you would have seen, our theme is water from oceans to taps. And it's very much keeping in line with the collaboration between the United Nations Environment Programme and the Global Network for Human Rights and the Environment to be engaging in activities that explore the different sort of facets and aspects and elements of human rights, the environment, environmental rights, what they mean, and how they might be put to use to kind of deal with circumstances of global crisis. And we feel like water is very much at the heart of that. It's sort of implicated and intricated in all aspects of our environments. We had two fantastic sessions today. We're really looking forward to this one. I am going to hand over to Bruce Wilson, who is our moderator today. Bruce is a professor of political science in the School of Politics, Security and International Affairs at the University of Central Florida, where I think he is right now. Bruce, over to you.
Okay, thank you. I should also acknowledge the thanks to the organizers for allowing us to have this panel here, and particularly to Jackie Dugard, who will hopefully turn up later on, who helped and did the legwork to put this together. So this project is serendipitous. It was a really interesting, timely project. It came at the 10-year anniversary of the human right to water. And so what it actually looked at, what we were interested in, is whether elevating human rights to water or to any other elevation of human issue to a human right actually matters. And if it does matter, how does it matter? So what we're going to hear today is, oh, hi Jackie, just so you right. So what we're going to look at today is one part of this project, and these are different aspects from the project. First, we'll have Arkaja Singh, who will talk about the decentered construction of human rights to water, right? And it turns out, well, she can explain this herself. Then followed by Chris Faulkner, who did this project looking at using natural machine language, learning language, to find out where and what has actually been written about human rights. You can see this explosion in human rights to water academic studies. Catalina looks at the domestication of human rights and whether this matters, because this has always been pushed as something that was valuable and useful for animating the human right to water. Namita White will look at the case of India. Inga Winkler will look at the case of the United States, which is actually a very ironic case, since in the US, human rights don't actually usually matter. They're not, you can't litigate usually on human rights, but that has some interesting aspects in the US. And then Jackie, who looks at this question of day zero in Johannesburg in South Africa, so we start from the macro and work our way down to a city level question of the human rights. Each author, scholar is going to talk for roughly 10 minutes so we can have questions and answers at the end from the audience. Okay, so without further ado, Arkaja.
Thank you, Bruce. Can you all hear me? I hope you can. It's so yeah. So for today's program, I will present our co-authored paper, co-authored by Dan Brinks, myself, and Bruce, titled "The Decentered Construction of Global Rights: Lessons from the Human Rights to Water and Sanitation." Ironically, I mean, Bruce introduced us as one of the macro perspectives, but actually it's a macro perspective that emphasizes the importance of the micro. And to get straight into it, what do we mean when we say the construction of global rights is radically decentered? What we mean by this in our paper, which I hope some of you will read, is that the construction, that to understand the process of construction of global human rights, one needs to look at processes, place, actors, and the production of meanings as all things that don't necessarily have a one starting point and an end point. The processes, in fact, include all sorts of struggles and claims of people who feel the lack of something that is essential to a dignified existence. And the places where this construction of global rights happens, for that we need to look beyond the conventional or the traditional ways of looking at the centers of international legal development, because the construction of global rights is actually happening in all sorts of places that have sometimes only a tenuous or episodic connection to those centers of international legal development. The actors who engage in this process are also not just legal actors, but includes all sorts of street level actors and bureaucracies and local groups who give the right, imbue in the human right to water, many different meanings and many different kind of combinations of meanings. So rather than local claims being trimmed or being shaped around a global right which has emerged from some international legal center, it's sometimes the other way around, where the right is actually being stretched or fitted or developed, and that the people who make the claim to the right have a hand in actually shaping its meaning. In our paper, we also emphasize that, we also found it quite interesting to this process that the most novel strategies and articulations of the human right to water are most likely to exist when existing legal frameworks do not meet the needs of rights claimants. And so, to a sociological reading of constitutional rights, even where we're looking at the process of recognition of the global right in national constitutions, we drew on the papers of this collection, this project that Bruce mentioned. In our co-authored paper, we drew on a lot of interesting, exciting, and new work that was done by the contributors to this project. Many of whom are present in this discussion. So, I won't go into the specifics of what they talked about, but what we made of it, which is, that the formal recognition of the right in national constitutions can also depend quite a lot on what the right means in that local context. So, for example, how much of in the way that right was being formulated when the process of constitution making was going on, how much of a claim on natural resources was it making? And, did it really constrain the actions of locally influential interest groups? Would they really have to put a lot of money behind the right? Or was it something that could stop at a symbolic level? This is one of the things that happened. And was it, if there was a significant claim, was it conceivable to those in power? It's also true that that constitutional recognition is not the only thing, because local courts could recognize the right even when it's not in the constitution. And that's, perhaps because water is life, and we'll talk about that, in many ways later, but also because international norm development happens all the time. And it's also, a social legal reading of constitutional rights also, points us to the importance of looking, for where it really matters. Namita Wahi's paper, pointed to the, very kind of contextualized and local meanings of the right, which has emerged for Dalits in India and for indigenous groups. So for Dalits who face a very specific kind of discrimination, there is a type of right that is framed specifically for their type of discrimination, whereas indigenous groups who have another type of battle to fight have made their own radical framing. Some of these claims are more successful than others, and that doesn't take away from the what meaning the rights have for them. Also, legal actors don't necessarily have the last word on the meaning of the right. So where the legal framework is restrictive and where it's oppressive or very pro-formal rights, and it doesn't speak to the living situations of those who are being denied water, those people may ignore that meaning of the right and press their claims in other places and in other language and in other formulations. In my own work on slum residents in Indian cities, they, sort of, in open defiance of the court's interpretation of the right to water. They engage directly with municipal bureaucrats and build a structure, with those bureaucrats, build a structure of access rights, which which use engineering tools and concepts, but ultimately rest on some normative idea, which forms the basis of this alternative formulation, which is that everybody must have the water that they need for their basic rights. What meanings bureaucrats and local bureaucracies give to rights could also encompass or exclude claims of equity and social justice. And where, the paper from South Africa, Jackie's paper, suggests that climate change and scarcity scenarios might bring back some of these broader claims that have been consciously excluded from local definitions of the right to water. Many papers, and it's not just our work, but the global literature on the human right to water often engages with the discourse around economic pricing and privatizations. The right to water is sometimes an aid of, sometimes sometimes a tool to oppose privatization, and sometimes a way to adjust some of the most harsh aspects of water privatization or the commercialization of its operations. And so the right to water is constantly shaped and reshaped and engaged around the discourse of privatization. Local mobilizations can, as we suggest through all of these, in all of these readings, can be in open defiance of legally sanctioned meanings and court rulings, and against the framings that bureaucrats give to the right to water. Water rights research and writing reflects this also in the fact that it is multidisciplinary. It's increasingly multidisciplinary, and it includes engineers and political scientists and geographers. But if it's so fuzzy and so kind of escaping meaning, what is the use of an international right? Is it of any use at all? And in fact, the right to water need to be recognized separately, because water is so fundamental to life and so fundamental to human existence that if you did not have global human rights language associated with the right to water, would it really matter? The global right has also been, of course, it emerged in the context of the privatization of drinking water services. And therefore, it's sometimes, treated as something that was in the service of a neoliberal reframing of water. Did the human right to water aid or impede, or, in how did it impact the delivery of human welfare? I mean, these are all, questions that have been asked around the international right, but all these questions emerge from the idea that there is one right, one kind of global edifice of rights, and that should be tested as effective or not non-effective. And that global edifice is built in an international, by international legal actors in a kind of international process, as opposed to a national process. But in fact, global rights as social legal constructions emerge from, are very loosely connected with this international process. And, it can, so it's not, it's not the top-down construction and its vernacularization that we're testing the efficacy of. So it's, its bindingness or its effectiveness is in fact not just a question of legal enforcement or welfare outcomes, but also something of political and normative value. It's also true that, that not the neediest people don't make the most right to water claims, right? There are particular contexts and particular opportunity structures where right to water claims emerge. And for this, it is very interesting and useful to map the spaces and the actors and the meanings of the right to water in different contexts and in different places where, our group of legals, this was very interesting to us, how our project and our group of scholars looked at these different spaces and actors and meanings. Because, these spaces, in sort of political geography could be local or national or international. They could also, in more practical terms, they could be legal, which means the constitutions and courts. They could be political in the sense of parliaments and, political mobilizations, technocratic and social. Naturally there's in the way we're looking at the right to water, there's a legal aspect and a social aspect. But we also, and we would also like to really emphasize the importance of this technocratic or bureaucratic space of the development of rights. And the reason why because it's often ignored. It's not, it's not the most important space, but it's something that has not been considered an arena that's very hospitable to rights claims. This is because bureaucracies work with their own sorts of logics and their own sorts of, framings of what they're supposed to do. But they're extremely influential and they interact with legal, judicial, and social spaces. And it's, and this is, to get a bit deeper into the bureaucratic spaces, it's not just about, it's not just the fact that the right to water has a significant engineering and governance interface, that it depends on, the state capacity to deliver water and technical and engineering standards. But actually this bureaucratic interface, the right to water just points us in this direction because it's so kind of visible in the discourse, visible in understanding water, but actually it applies, to all sorts of rights, even the negative ones, because all of them depend on a state apparatus and a bureaucratic framing and machinery to, to actualize and make those rights real. There is in some places where we talk about the right to water, especially in urban contexts, a techno-institutional sort of service delivery frameworks, where these are well developed and where these are kind of legislated and institutionally established. This, this is another, this is obviously a very active arena where this happens because it gives the impetus to service delivery claims in the courts. And, we see this in the places where these delivery frameworks exist, that the right to water gets shaped in certain ways around it. But bureaucratic spaces, even where these do not exist, even where that service delivery framework and that legislative framework in which you can make service delivery claims is not present, and where the constitutional recognitions and other sorts of options are all closed, bureaucratic spaces are of value even there because they could allow for negotiations when other sorts of options are closed. And so I'll end here. I wanted to talk a little bit more about the bureaucratic space because it's especially of interest to me, and because in my own paper on municipal service delivery, I dealt with that bureaucratic space. But many other papers in our collection also engage in various ways with the kind of service delivery paraphernalia of the state, and the meanings and the contestation that happens around the right to water with local bureaucracies. And so, yeah, thank you for this, and I'll end here, and I look forward to hearing my colleagues.
Thank you, Namita.
Arkaja.
Sorry. I'm reading the list here. I'm halfway down the list, sorry. Arkaja. No. Very interesting. Chris, did I get your name right?
Yeah, good morning, good afternoon, good evening, everyone. I have a presentation. I'm going to try to share the screen, so hopefully there's not too much of a technical difficulty on my end. So I'll check with the audience to see if we can see the PowerPoint presentation. Good, okay. And I'm going to try to move into presentation mode too, so hopefully it retains the slides. I'll ask one more time if that's good. Perfect. Thank you. So it's nice to be with everyone. This for me is kind of a new field. I do a lot of research on human rights more generally, but was fortunate enough to have an opportunity to work with Bruce on this project. And we think it's kind of an interesting piece because we adopt natural language processing and machine learning tactics to try to understand the trends in academic publishing. So the title of the project, The Human Right to Water and Sanitation, using natural language processing to uncover patterns in academic publishing. I have to offer a disclosure here. I'm at the U.S. Naval War College now, so what I say here represents my own personal views and not the views of the DoD or the U.S. government. My colleagues on this project were Joshua Lambert, now at FactSet, working on economic, social, and governance challenges. Dr. Wilson, and then my younger brother, Dr. Matthew Faulkner, is at San Jose State University. So we'll kick it off with why we were interested in doing this. And I think Bruce mentioned here early on that we're interested in understanding if the elevation of the right to water in the international discourse has actually led to any meaningful changes in reality. And we kind of took that a little bit further to suggest, did it matter for what scholars are actually looking at and how the trends in academic publishing may or may not have changed, maybe with this inflection point in 2010. Importantly, though, this isn't just something for, how do we call it, for the academic community, but more interestingly, to try to understand these trends so that practitioners, NGOs, the UN even will kind of understand where we are, where we're going, what's been done, what needs more attention. So that was really the motivation of it. And I have up here a couple interesting time periods, or excuse me, junctures in time that might help us understand why we might see some of these variations and trends. And so we have the general comment, number 15, kind of suggesting that human right to water is inextricably linked to other human rights, existing human rights. We have the July 2010 adoption of the human right to water and sanitation. And then something really interesting that we uncovered very early on in this project is this graphic on the right will kind of illustrate to you the yearly sum of publications over time, with the y-axis showing the yearly sum and the right y-axis showing the cumulative sum over time. So what we see here, a general upward tick, but 75% of articles since 1990 have been published within the past decade. We think that's important. Our temporal scope is 1990 to 2020. Some practical reasons here for doing so, and some limitations with what we could actually get access to. But we've seen a dramatic increase and influx in the number of publications focusing on the human right to water and sanitation. This is kind of the boring methodology stuff, but our project really is methodologically heavy because what we're trying to do is use some new techniques to understand patterns in publishing. So we utilize two prominent abstract and citation indexing databases, the Web of Science and Scopus. What we essentially did here was we entered in a bunch of search strings. I've got some examples here and this bullet point, the human right to water, constitutional right to water, right to sanitation. The next slide will show you kind of the all-encompassing list that we used. It's very busy, but the idea here was to try to be as exhaustive as possible in listing topics that might be or fall within the purview of the human right to water and sanitation. You can see that we found something like 15,000 to 19,000 publications between the periods of 1990 and 2020 on papers that were related to our search strings. And then through a filtration process, dropping duplicates across these citation indexing databases, we arrived at a total corpus of publications of around 14,000. So what our goal here was to do two things. One is on the first slide, illustrate the descriptive publication patterns. How is this changing over time and space? And then the second, and probably the more interesting one to the audience here, the topic modeling. What are people actually talking about as they write about these things? So the methodology that we utilize, natural language processing, machine learning, we're essentially taking all of these, what we'll see, the titles and abstracts of all these academic papers. And there's some inherent limitations in that. And reading them to uncover patterns in these publications using natural language processing. So what this essentially relates to is we end up with a series of various topics that we then label that give us trends in what is actually being discussed. So I'm happy to talk a little bit more about the methodology, but it's kind of boring, and we'll move on to give you kind of an idea of all the different topics that we investigated. Now, I don't expect you to look at this. If you look at this and you're confused, good. This is just kind of Boolean search. All the things in quotation marks, all the terms in quotation marks are essentially the things we looked for. And so we were able to run this through both databases and come up with our kind of sample to draw from. Now, some interesting patterns emerge here, and this is just a graphic showing you the main journals publishing on topics related to the human right to water and sanitation. And as you can see, what I think is most interesting and what most in this field are probably familiar with is the multidisciplinary and interdisciplinary nature of the topic. So we see some journals that are very clearly rooted in the social sciences, a few legal journals, some physical science journals, which I thought was very interesting. And in conversations with Bruce, we've arrived at this idea that, hey, there's some really important stuff being done on the human right to water in the physical sciences, focused both on environmental issues, focused on water treatment. And so over time and space, what we've seen here is a significant variation in the types of outlets that are publishing on these topics. Now, this graphic here is just an illustration of the topical trends and probably the most important one. The most important ones as we identified in our project. There's a few limitations that I'll hint at later in this presentation on some of the challenges in labeling various topics. But in our natural language processing search, the short story is it spit out clusters of about 15 to 30 words under 30 different topics. The authors are then it's incumbent on the authors to then label those. In other words, to make sense of what these topics actually mean. And so some important things that emerge here, you'll notice the easy way to look at this graphic is the longer the bar is, the more salient the topic is over time and space, the more people are writing about it. And so the top 5, as we listed here, number 16 in particular, water security and supply, topics 3 and 30, water quality and treatment, water research, governance and development, coming in and kind of second and third. We have water policy and management. And then this 5th most important or most salient across our corpus of research, climate factors, and water. And so again, I'm happy to talk about this in the Q&A more for those that are interested. But I thought it'd be useful to kind of think about how these have evolved over time and space. And what you see here is, if you want to look at the y-axis, this is basically telling us how salient this particular topic is across all publications from 1990 to 2020. And so these are the top 5 kind of graphically depicted over time and space. There's a few different things that you'll see here. Water security and supply topics focused on this in particular have really stayed in the lead, if you will, and it can continue to increase since 1990. When we look at something like the lower importance, water research, governance, and development. I think it's interesting that if we look at publications in the early 1990s, this was probably the least salient topic covered by scholars. It's now, although these are all kind of converging towards the end, it's now jumped to the 2nd most salient topic covered over the last 5 years or so. Also an important trend here, climatic factors in water, maybe unsurprisingly to the audience here, has steadily increased since 2010. I think our expectation based off of the relevance of this kind of climate, water security, and human rights intersection is that this might continue to tick up in the foreseeable future. And so to keep this as brief as possible, I think I'm okay on time, but some conclusions we have arrived at. And again, this is kind of the first cut of a more rigorous attempt to maybe understand patterns in academic publishing that can really inform this community here on things that we've done well, that we focused on, but things where we might have opportunity to build out a more robust research agenda. So I kind of conclude with the idea that synthesis design, these types of techniques, machine learning, allow us to engage with a lot of different interdisciplinary and multidisciplinary research and understand where we are, where we're going, what we're missing, and so on. I think it's also illustrative of the benefits of these new and methodological strategies for the broader field of human rights. So this method can be applicable to as narrow or as wide a scope as we'd like. I think in this case, it was really informative to me to think about where researchers have been focusing their attention. Some things that I think are important, climatic research and the human right to water and sanitation is increasing in frequency, as I kind of alluded to on the last slide. I think this will continue to take place moving forward. But some other ones that we, that long list of topics, some other ones that are interesting, popped out a little bit, but didn't have as much clear research on the topic, or at least the topics weren't as salient as some of these other, were water and conflict and water and health. I think given the COVID-19 pandemic and the inextricable linkages between human right to water and issues related to health and well-being, we might expect more. So I think there's opportunities within both these fields, me as a conflict scholar and those interested in health and human rights, to think about how the human right to water and health can be more researched. One thing that stood out, maybe the last major thing that stood out, there was far less on sanitation when looking at the human right to water and the human right to sanitation together. So when looking at this entire field, very few of the topics could be categorized as explicitly looking at sanitation issues. I think Dr. Wilson and a few colleagues have kind of explored this. It's really hard to get this information. Some of it's absorbed in the human right to water research, but there's a lot of opportunity to develop a more robust research agenda focused on issues related to sanitation explicitly. And lastly, I'll conclude, as I always do, with some limitations. One thing that we didn't do in this project is look at the number of publications as a ratio of the number of journals per year. So you could easily look at the first graphic shared in this temporal scope and say, well, it's just that there's more journals to publish in. That's why we've seen this dramatic uptick. That could be, but I think the sharp increase in the number of publications would suggest that there is a robust community focused on this. And then the last limitation is there's some subjectivity in labeling the topics. That's a area I can go into a little bit more in a Q&A session if of interest, but the idea behind it is it's incumbent on the authors to essentially categorize these topics. And so there's some challenges with that, but all in all, I think, this project illustrates a useful starting point for trying to digest a really interesting research area. So thanks for your time.
Thank you, Chris. If you have questions, you can put them in the comments box on the side, and they'll be cut. You also at the end, you can also ask questions live if that's what you just want to remind you that was there. So the next paper is Catalina Vallejo, who looks at the domestication of or non-domestication of rights through constitutional changes. Catalina.
Thanks, Bruce. Should I share my PowerPoint or will you?
Yes. Could you share from yours?
Yeah, okay, then I will share it. Okay. Let me know if you can see my presentation. Yes? Okay. So our paper is called Comparing Experiences of Constitutional Reforms to Enshrine the Right to Water in Brazil, Colombia, and Peru, looking at the opportunities and limitations. I wrote this paper with my colleagues Lara Cortez, Camila Janela, and Angela Paez. So I'll divide this this presentation in three parts, like what was our question, what was our inquiry, what we found, and some lessons learned. So these are the Latin American countries that we studied. They have many similarities when it comes to water problems, when it comes to the use of courts for the judicialization of social rights, when it comes to having both new constitutions with a framework of rights, but also having gone through neoliberal reform in the 90s. So the three countries have quite a lot of similarities and also share an important big portion of the Amazon rainforest. So there are a lot of also environmental and collective aspects of rights that are relevant in the three cases. So first of all, our inquiry. So in the paper, we compare recent constitutional reform efforts to include a self-standing human right to water in Brazil, Colombia, and Peru. What we wanted to do was to understand the role of the existing domestic legal frameworks on drinking water and water provision and management in relation to the approval of constitutional amendments. When the UN resolutions on the human right to water were approved in 2010, Brazil and Colombia already had recognized an extensive list of human rights, including individual rights and socioeconomic rights, that could be considered to encompass the right to water. And also, the two countries had a strong legal opportunity structures for the enforcement of social rights in the courts. Peru was not that similar. So Peru had a a weaker list of constitutional rights, and much weaker also legal opportunity structure for the enforcement of rights through the courts. So Peru, in contrast, doesn't have justiciable rights in its constitution, and so the opportunities for social movements to enforce rights are completely weak compared to the other two countries. So surprise, surprise, however, what we saw is that Peru passed a constitutional amendment in 2017 to have a self-standing right to water, human right to water, while Brazil and Colombia, even though they have seen much of right to water activism and social mobilization about this topic, have so far not succeeded in passing these reforms. So we wonder what's happening here. That's an interesting comparative puzzle. While in Peru, the constitutional reform was, so what we saw that while in Peru, the constitutional reform was led by political parties in Congress. In Brazil and Colombia, social movements were the ones starting with the promotion of initiatives towards enshrining the right to water, but then run into governmental and legislative problems and hurdles that have not been overcome so far. These different outcomes are interesting, and we see that the weakest constitutional protection of socioeconomic rights in Peru. And also in Peru, there is much less frequent constitutional reform altogether, while Brazil and Colombia, constitutional reform is very common because we have very detailed constitutions. So the constitutional regimes in Brazil, the Constitution of 1988, the Constitution of 1991 of Colombia, and the 93 Constitution of Peru are part of a phenomenon known as the Latin American neo-constitutional movement, which took place in parallel to the expansion of neoliberal reforms, as I mentioned before. And so we thought our study would be a contribution to scholars and also policymakers interested in understanding the regional and domestic dynamics in Latin America that may limit the full implementation of the human right to water for everyone, in a context of equality, as it was urged by the United Nations since 2022 and then reinforced in 2010. Okay, what we found. So we explored the role of the existing domestic legal frameworks on drinking water provision and management in the three countries, and how this will facilitate or limit constitutional amendments. So we found that the three countries already had, before 2010, specialized status, water government institutions, and constitutional jurisprudence connecting access to water with human rights, with the human right to health, the human right to life. One key feature that distinguishes Brazil and Colombia from Peru is that while the first two countries have seen a lot of mobilization, Peru passed the right, but there hasn't been a lot of mobilization after passing the reform. We found that the three countries, the existing legal frameworks have managed to improve access to water somehow. So this we cannot deny. They have improved access to water, especially for urban sectors of the population. But there has, and for certain individuals, in connection specifically to the right to health and life. But these rights have not solved the problem of equality and water quality for everyone. And the lack of access of water for many rural communities, including indigenous communities and farmers. And the constitutionalization of the right to water plays a role in changing also state duties to provide water. And this has proven useful tools for the advancement of the protection of the right in certain urban sectors, but it can also be very expensive for states to actually provide infrastructure in rural areas. And this inequality is historical in the three countries. So this is what we found the right has not managed to change so far. So in the cases, what has been useful in cases when low-income petitioners in urban spaces have claimed the right to be reconnected to water supply because they didn't pay the fees because of lack of funds or because of inequality. So then the judges have been ruling in their favor and connecting the right to water with life and health. But this is not for everyone. This has to be a very specific threat to life or health. So this we found as a limitation. Peru, as well as Brazil and Colombia, in the cases, water quality and availability are affected by increasing deforestation, land grabs, and industrial land uses, including mining and extensive agriculture. And the 3 national development projects or programs favor extractive industries. So this is another aspect, more collective aspect of the right to water or the protection of water, which will end up having an effect in water quality and access for everyone that has not been really impacted by the rights. And in the 3 countries, these problems affect the entire society, of course, and ecosystems, but they disproportionately affect indigenous peoples and rural inhabitants. So protecting socioeconomic rights as the right to water is costly for governments, and constitutionalism limits the power of the ruling powers, of course. And interestingly, not promoting human rights can be politically costly as well. So we found that this is what happened in Peru. The forces' intention seem to be influencing constitutional reform processes in the 3 countries in different ways. So while in Peru, not passing a right to water sounded as a very politically incorrect way to go, in Colombia and Brazil, approving, so for Congress people, approving the fundamental right to water will mean actually spending a lot of money or having to find resources for bringing water provision to the rural areas as well. So that then the political cost was very different from that of Peru. Also, here it's very important to note that as in Peru, it is not so easy to use the courts to for the enforceability of rights. Then having a right that is not that dangerous, so to speak, for governments, it's easier to pass than in countries where legal opportunity structures to actually enforce the law through tutelas or other emergency legal actions is more likely. So some of the lessons learned for us is that definitely political cost is an important element to consider. We don't know if this plays the same role everywhere, and we don't know if this will play the same role all the time in these 3 countries, but at least we think it is an important factor to consider when studying the implementation of the human right to water or the inclusion in new constitutions. So for some countries, the cost of including a provision within their constitution may be very low and effectively render the constitutional promise as cheap talk, as we argue happened in the Peruvian case. And so not every country bears a very high cost of adopting constitutional language for what rights. While in Colombia, the political and financial costs were too high and have discouraged legislation from approving a constitutional reform. In Brazil, it is difficult to say how costly a constitutional amendment would be to include a right to water, because there is because of the current issue with privatization of water provision. While there is a connection with human rights, very clearly done before by the courts, there is also a very strong tendency towards privatization of this kind of services in Brazil. So the 2 legal reforms are in tension with one another. And our analysis, so to sum up, our analysis of recent constitutional reform processes in Brazil, Colombia, and Peru lead us to conclude that the enshrinement of the right to water in the three constitutions is marked by three key elements. The first is the differences in how diverse interest groups want to use the right to water, or the meaning they want to give to the right to water, as Arkaja was mentioning. It's an important factor, and it can be very different from country to country, even if they are neighbor countries. The second key element is that the different incentives guiding members of congresses, to accept or reject these attempts of constitutional reform vary from country to country as well. So what in one country is a strong incentive to pass a reform and look good for the rest of the population, in another country will make politicians or Congress people look actually bad, because they are, as some say, endangering public funds and irresponsibly deciding on how to engage public funds. And the third and last element is that existing legal opportunity structures to enforce the right to water was once recognized, in turn act as incentives, both for social movements to push for more reform. If they have a legal opportunity structure, they will try to push for more reform, but also at the same time for the ones in power to accept or reject them. Okay, this is our last slide, and this there are more details in this paper, and I welcome everyone to just take a look, to read them, and contact the authors if you're interested. Thank you very much.
Thank you, Kat. Next is Namita Wai on the.
Thank you, Bruce. Good afternoon, good morning, good evening, and since it's almost midnight here, good night to everyone. Thank you, Jackie, for organizing this panel, and to Dina and everyone at the Global Network on Human Rights and Environment. I think the fact that people here are from all over the world sort of confirms what Christopher is finding in his work, that this is an issue that is really exercising the imagination of everyone everywhere. And I think speaks to the topic itself. Is not something that can be seen in silos, from oceans to taps, means that it is part of an indivisible ecosystem. And so when we talk about the human right to water, it is one of the later rights to have been articulated as a human right. And as Bruce said at the beginning, 10 years into the right, it was a good time to look at what impact it has had, but also how it came into being. And the interesting thing about the human right to water is that it has been articulated as a human right at a time when there has been a fierce attack on the human rights movement. The critics of the human rights movement have argued that human rights only bring about status equality, not distributional equality, and that in fact prevent other forms and methods and struggles that might actually lead to better distributional outcomes on something as basic as water. I mean, we can live without food for as long as 3 weeks, but we cannot live without water even for 3 days. So why do we need to have a human right to water? And I try to examine this question by looking at the evolution of the right to water in India. India, as you know, is the world's largest democracy. It is home to over 1 billion people. It has 18% of the world's population, but only 4% of the world's global renewable water resources within its territory. So obviously there are huge issues of water scarcity. About 50% of India's population, that is 600 million Indians, are facing high to extreme water stress, which is only likely to be exacerbated by climate change. But the access to water scarcity is not just an issue about the quantity of available water. It is also about issues of distributional inequities in access, as well as the quality of water. And of course, you know, the human right to water is also about the right to sanitation, and so access to sanitation services as well. So in my paper, I looked only at the human right to water, although I do make reference to an important decision on sanitation by the Indian Supreme Court. But on the human right to water, India was ruled by the British colonial state, first by the East India Company and later by the British Crown, for over 200 years. And what I found was that even during the colonial period, courts in India had articulated a legal right to water. Now, the colonial state never recognized any obligation to provide water to the people. In fact, it followed, as it did in the case of land and forests, an extractive policy, essentially to maximize how much resource they could extract from land and forests, but also from water for the purposes of irrigation channels. Now, ostensibly, these irrigation channels were justified as a way of bringing about water to areas that needed water for cultivation of food grain, but actually it was just part of the British policy to ensure that there was more food production, which could lead to exports and so on. And which is why we find that the irrigation canals that were built were poorly planned and implemented in India. So, but that's the backdrop. And so I looked at two original data sets, speaking of the methodology of the paper. One was a data set of over 150 water-related laws, and the other was a data set of over 250 cases decided by the Supreme Court and High Courts on the right to water. And in doing this work, I found that the high courts in India, which predate the constitution, some of the high courts that we have date back to the 1860s, there was a legal articulation of the right to water, which included water for, livelihood as well as drinking water, even prior to independence, but very little about drinking water prior to independence. India becomes independent in 1947. We adopt a constitution in 1950, which marks a break from our past of colonial subordination and domination. In the constitution, there is the articulation of the fundamental right to life. And as Vishwanath has asked in his question, indeed, the court has worked with the materials that were before it and articulated the right to water as a concomitant of the right to life, just as it has done with other social and economic rights like the rights to food, housing, health, and education. And what we find is that both the Supreme Court and the High Courts have articulated a minimum content of the right to water. I also analyzed in the paper how various laws were enacted to deal with pollution of water resources in the 70s and 80s, the Water Act, the Air Act, and so on. And the court has essentially read out obligations to obligations on the government to ensure that water is not polluted as a way of fulfilling the right to life and the right to water of the people. So what that means is that even though the courts have articulated a content of the right to water, and we see more drinking water claims post the constitution than before, the court has not imposed an obligation on part of the government to provide water either. But what we do see is that at the High Court level, more recently, there have been some progressive decisions which have, in that particular case, imposed an obligation on the government to ensure that people's drinking water is not cut off. So again, it's not an obligation to provide water to everyone, which is something even as activist a court as the Indian Supreme Court cannot do. But it has essentially said that the courts have said that where there is pollution of water resources and somebody has to be held accountable, there should be, because it is violating people's right to water. And that right to water includes both drinking water and water for livelihood, including water for irrigation of agricultural land. So that is the mainstream articulation of the right to water that has happened in India. But I also look at two specific articulations of the right to water, and Arkaja alluded to this in the beginning in her presentation. The first is that by Dalits or scheduled castes. So these communities constitute about 16% of India's population, so not an insignificant number. And this community has been, because of India's historical caste system, they faced historically systematic discrimination within society, including as it manifested in the form of not being able to mingle with other castes and access common sources of water. And again, because the burden of fetching water in rural India falls mostly on women, it's Dalit women who have experienced the harshest effects of this kind of discrimination. In that context, because human rights are essentially dignitarian rights, and the human rights discourse is a dignitarian discourse, I found that there has been a significant articulation both through the judicial decisions as well as through laws that have been enacted that seek to undo this kind of discrimination through horizontal application of rights, even against people who are discriminating. So the state is under an obligation to ensure that even private actors don't discriminate against Dalits. So in that sense, what the paper finds is that, in societies with entrenched discrimination, like the caste system in India and perhaps in other countries as well, status equality does matter, because not everybody has the same status or had the same status when those rights were guaranteed. That being said, the Indian government in 2000, for the first 4 decades post-independence, did not even have a national water policy and has till date not recognized an obligation to provide water to its people. There has, however, been, in 2012, a national water framework bill was drafted, which for the first time did articulate a right to drinking water and an obligation part of the government to provide water. But it's 10 years later, and this bill has not been passed into law. Interestingly, however, neither the Supreme Court decisions, there's hardly any reference to the human right to water internationally, nor does the bill which the government has. So the government, the bill that has been drafted by the government states that the right to water definition in the bill alludes to what the Supreme Court has identified as the right to water. And again, there is no reference to the international human rights discourse on the right to water. However, so in conclusion, even though the recognition of the right to water, the first conclusion is that the recognition of the right to water in India has largely occurred independent of the processes and movements that have led to its recognition at the international stage. The second conclusion is that the recognition of the right to water has by itself not resulted in better access and quality to water. But what we have seen over the years is a growing recognition of an obligation upon the government that it needs to provide drinking water, and it needs to ensure that there is quality water and that water is not polluted through legislation that the government has enacted, through legislation that Parliament has enacted over a period of time. And the motivation for all of this is coming from the courts. And we see that not just in the case of the right to water, we see that in the case of the right to education and the right to health. All these bills that have articulated these rights in law. For example, in the right to education, we actually did have a law passed. In the right to health, it's a draft bill. They all refer to the Supreme Court's articulation of the right. So clearly, the judicial articulation is driving the recognition of it by government and in policy. In contrast, however, there is another marginalized group in India, which are the indigenous communities, and they are called the scheduled tribes or Adivasis. They constitute 8.6% of India's population. Again, not an insignificant number. There are about 104 million Adivasis in India. And we find that the indigenous imagination of water rights sees land, water, and forests as one inextricable, indivisible whole. And in India, we have this movement called Jal Jangal Zameen, which stands for water, forest, and land. And so according to the indigenous articulation of water, it cannot be divorced from land and forest. But what we find is that the mainstream articulation of the need to provide drinking water to millions of Indians has led to a huge emphasis on big dams and hydropower projects, which in turn has been justified by the courts as being the right thing under the human right to water, even though it results in marginalizing indigenous people further, because my research at the Land Rights Initiative shows that most of the dams are in areas that are recognized as indigenous areas. And as a result of which, the indigenous populations have disproportionately borne the burden of the human right to water of the rest of the population, because even though they are only 8.6% of India's population, they constitute 40% of all people who have been displaced since independence, and some more than once in one lifetime, largely due to dams, national parks, wildlife sanctuaries, and mining projects. So in many ways, even though the criticism of the human rights movement as actually not ensuring the distributional outcomes that we want, would benefit from articulating the indigenous claims, but actually both the human right to water and the critics of human rights discourse have completely ignored indigenous claims. So Samuel Moyen's influential book doesn't make any reference to indigenous communities anywhere in the world. And the earlier critics like David Kennedy, who have critiqued the international human rights movement, also don't refer to indigenous communities. But in many ways, the very fact that today we are talking about human rights and the environment together is a nod to the indigenous imagination, which essentially looks at human beings as being part of the environment, that we are not separate from the environment. And therefore, whatever for what you know, in our country's development seems to be reified always, is that it has to be done with that imagination. It can't be that we develop at the cost of our water resources and our environment, and then we fix the damage later and we mitigate later. No, really the indigenous imagination is that we see ourselves as part of this whole, and every policy that we make has to be informed by that imagination and not the other way around. But unfortunately, the human right to water and its articulation, though dignitarian, remains individualistic and remains confined within the mainstream understanding of human rights, which do not see us as being part of the environment, but rather as separate from the environment. So I'll stop there. Thank you.
Thank you, Namita. Next one, I think, is Inga Winkler, talking about the US, which another interesting case. Inga, floor's yours.
Hi, everyone. Well, I hope you're still with us. I realize this is a lot. So what I would like to do is take you to the United States and speak about my experience of engaging with the human right to water movement in the US. And as Bruce mentioned, it is a curious case because the US is not known for being, let's say, particularly friendly towards economic, social, and cultural rights like the human right to water. Well, and I think that makes it all the more interesting to look at how the human rights movement has actually used and conceptualized the right to water. This is quite different from some of the other papers. I mean, we don't see that much engagement of state institutions. We don't see that much engagement in the courts, but I really want to focus on social movements and how they use the right to water. So this research, basically, I mean, it dates back to 2012, or started in 2012, when I arrived in California and then spent the last decade almost in the US. And I remember that first time I went to the Central Valley in California, and we started working with communities there. And we saw all these small villages, small communities with dilapidated infrastructure that were experiencing nitrate contamination. We saw lots and lots of sewage overflowing in people's yards. We saw water coming out of people's taps that they weren't able to drink. We saw people who extensively relied on bottled water. And starting from that, I've become more and more engaged with communities across the US. And what we basically saw is that so many other people, whether in Michigan, Alabama, in Appalachia, basically all across the country, we have these pockets of often small communities that face water contamination, that face terrible rate increases, who experience disconnections, who deal with infrastructure that is basically falling apart. And I think the consensus is that these situations should not exist in a country that is as rich as the US. What's interesting about it is that there's also a really vibrant civil society network that is more and more coming together to address these situations. And well, from my perspective, and in this context, the most interesting aspect about it is to what extent people rely on human rights. And as I said, that is in a country that is really hesitant to engage with socioeconomic rights. So our question was, well, why has civil society embraced the human rights framework, and how did they go about that? And let me just quickly point to a few of our findings. So the most important one, the most important reason for turning to human rights was really this feeling of validation, this feeling of being listened to, being taken seriously, having systemic racism in the US acknowledged, and having this connectedness with this universal framework. That is what advocates told us over and over again, that human rights provided that validation when engaging with different mechanisms, when engaging with each other. And then based on that, they saw human rights as a tool that can amplify beliefs in affecting change. They saw it as a tool for collective agency that can lead to collective action and ultimately then community success. So it was this collectivity, this solidarity, this empowerment that people spoke to, where often, I mean, to begin with, they had feel isolated with these water struggles that only seemed to affect their community, and slowly by coming together with others, that turned into this collective attitude of we can. And there were people, for instance, coming together at a large social movements gathering in Detroit, where people shared their experiences and basically said, well, we never thought that you in West Virginia, or you in Detroit, or you in Alabama, or you on the Texas-Mexico border experienced something so similar that really resembles our own struggle. So there was lots of power in this coming together. And then finally, what we found is that communities and activists really saw human rights as an alternative framework, as a framework they could turn to, and actors they could turn to almost instead of the government. Because the government, they're mostly institutions they distrust, institutions they don't really expect that much from, institutions they have started to engage with over and over again without much success. But I think that's really where the real paradox lies, because we all know that human rights actors don't really hold that much power. They can't really replace the government. They can't go in and basically force government actors to provide services. But what communities saw is that they saw the symbolic legitimacy for their advocacy, and they got that through the engagement with human rights actors. So obviously they were aware that international mechanisms provide no real alternative, that there is no world court for human rights, that there's very limited reliance on litigation in the US. It's very difficult to really enforce any of that, but they still they gained this validation through that framework. And just to briefly look at the how government, civil society actors engaged with the human rights framework, we saw that at all levels of government, at the local, at the state, at the national, less than national, but also the national government. And activists were consistently taking signals from government actors to decide on how to engage. And one of the advocates we spoke to, who's been engaged in the struggle for decades, explains it as a triple-pronged approach of agitation, litigation, and then legislation and policy. So depending on what signals advocates were receiving from political actors and the political opportunity structures they saw, they kind of moved back and forth between more adversarial and more cooperative or constructive approaches. So it was this constant swinging pendulum that we basically saw between, I mean, on the one hand, using destabilization through civil disobedience. We saw extensive marches and protests and rallies, lots of direct acts of civil disobedience where, I mean, for instance, activists blocked some of the trucks that were supposed to disconnect water services. But then we also saw lots of more direct lobbying, lots of development of policy proposals. We saw advocates that developed very concrete water affordability plans. We even saw advocates that then moved into office themselves. So it was this constant back and forth and these very strategic choices where advocates kind of tried to understand, did spaces open up, then yes, we will engage directly and cooperate, engage, develop constructive proposal. Or once they closed again, they also moved back to more adversarial approaches. So for instance, in Michigan, one of the most recent actions we have seen is going back to litigation against the state, and I think this adaptiveness, this persistence, this ability to identify opportunity is likely what explains some of the, well, very small, but some of the successes that the movement has seen in addressing the water crisis in the US. Thank you so much.
Thank you, Inga. Really interesting. The fact, as I said, this is slightly moving from the macro down to the national and then the local. So Jackie Tugard's talking about the day zero in South Africa. Jackie?
Thanks very much, and thanks, Bruce, and thanks to everybody and to Dinah for this panel. So I'll just try to be very quick so that we have a few minutes at least for questions. I want to look at the day zero crisis in Cape Town in South Africa, and being part of this project, I wanted to really examine what I saw as an apparent paradox, and that paradox being the fact that South Africa has, as a legacy of colonial apartheid, very many water-related inequities that were inherited around the time of the constitutional transformation in the early 1990s, and that gave rise to a new constitution, which in 1996, what we call our final constitution, entrenched the right to water. So long before, well, not too long, but certainly before the international rights. So the paradox that I was looking at is a country that has a lot of water-related problems, and yet one of the most progressive constitutions in the world, including a justiciable right to water. So the question then, and then added to that was the fact that in the almost 30 years since the democratic transition in South Africa, there have been very little water rights cases that have been articulated in the courts. Indeed, only one right to water case has so far appeared in the Constitutional Court, when compared with, for example, upwards of 40 to 50 housing rights cases in the Constitutional Court. So my question then was, well, if we have water-related problems, we have a justiciable right to water, and other socioeconomic rights are being litigated and adjudicated, what is going on here? And that posed obviously a methodological question, which is how to investigate a negative. So how do I investigate something that isn't there? Water rights cases in the courts, why are they not there? So what I decided to do is to look at a clear example of a water-related problem, excuse me, and to see how that was articulated and experienced, and really mostly how it was framed by the people who experienced it. So during the time of the research for this project, a very clear water-related issue presented itself in the form of Day Zero in Cape Town. So Day Zero was a crisis, a looming crisis between 2017 and 2018 in the city of Cape Town in South Africa. And it was famously going to be the first major metropolitan city in the world to run out of water. And there was actually a date put on that. And that was put in terms of sometime in March 2018. In the end, through very strict water conservation measures, including the imposition of water management devices on households using more than 50 liters of water per person per day, in the end, these measures averted the crisis. But for a range of reasons, including climate change, Cape Town remains a very vulnerable city in terms of water insecurity. So I looked at how, if not through water rights per se, if not in that articulation, how was the crisis perceived and experienced and framed? My methodology was to look at news reports, online news reports during the duration of the crisis, and to interview stakeholders, including people in rich neighborhoods in Cape Town and people in informal settlements and townships in Cape Town, to see how the crisis was experienced, articulated and framed. And in terms of the reflection, what the results were very, very clearly was that most of the articulation of this crisis was not in a right to water frame. Now, of course, I'm not suggesting that water rights are not related to other rights, and I completely agree with arguments around indivisibility of rights and etc. And that's really where I'm getting to in terms of the findings. But for the purpose of this project, I was looking strictly at whether people used a right to water hook per se. And what I found was that they really did not, hardly at all. And that two very dominant frames emerged. One was a water justice or fairness or equality argument and instantiation, and also water governance. So these two frames emerged very, very strongly as opposed to a right to water frame. And so just very briefly, in terms of my reflections on this as to why that might have been the case, I think in the first instance, a restriction perhaps of to 50 liters of water per person per day, which is quite a severe restriction, especially if you have waterborne sanitation, but that it perhaps did not rise to the level of a severe violation of the right. In fact, General Comment 15 on the right to water from the Committee on Economic, Social and Cultural Rights really indicates that 50 liters per person per day is kind of a minimum basic amount to ensure a dignified and healthy existence. So setting these water management devices at 50 liters did arguably ensure a level of utility for using water which didn't rise to a violation of the right to water per se. So that's one possibility why the water rights frame perhaps didn't emerge and why there wasn't litigation about it. But the second thing I want to suggest is that there is something, and this is really, I think Arkaja mentioned it, and quite a few people have touched on it, that there is something perhaps particular about water compared with other socioeconomic rights. For a start, it's the only socioeconomic right that is really, to some extent, a finite resource, other than land, which sometimes is not included in the basket of socioeconomic rights, but it is a very specific right, socioeconomic right. So, and it is obviously also, as Namita has said, it's the right that is the most directly necessary. So many people in my research said, well, we have to make a plan. We will make a plan because we have to. So people don't really think of rights-based litigation or mobilization. They make a plan one way or another. So I think it falls into a different kind of a thinking process and mobilizing process than a rights-based instantiation per se. And I also think that related to that, I want to tentatively suggest that perhaps the right to water can be seen, and certainly in South Africa, it has been more of a derivative right, that it is accessed via other rights. So in South Africa, very much it's accessed largely through your right to housing, for example, or your right to land. So you access water as a function of, do you live in an informal settlement? What are your rights in that informal settlement? So it has to do with your access on the land. If you live in an urban area in a house, it has to do with your, if you, for example, a tenant, it has to do with your relationship with the landlord. So it has to do with your tenancy rights, etc. So I want to tentatively suggest that it is perhaps a very complex right, that it is often a derivative right. So sometimes it's accessed through the right to housing, sometimes through environmental rights, but in South Africa, very rarely has it actually been articulated as a right to water. And then finally, I want to say that in South Africa and in Cape Town, perhaps it's not surprising that the equality lens was the most prioritized and at the forefront of people's discourse, because South Africa is the most unequal country in the world, and Cape Town remains an extraordinarily segregated racially and class-wise city. So it is perhaps not surprising. And I also want to suggest that it, in the end, doesn't matter, precisely because of the indivisibility of human rights, that it really doesn't matter which right is used. The important thing is that there is a rights basis for people to make claims, to articulate, to think, to dream, and to think of a more equal and just world full of dignity, as Namita had prioritized in her presentation, and through access to the basic goods. And then finally, the very final thing just that this research made me think about was that perhaps in an increasingly insecure world where water, we all understand that water scarcity is going to become more and more acute, that perhaps these questions about distribution, again, Namita spoke about distribution as opposed to the actual amount of water. And this is something that was picked up in the UNDP's Human Development Report as far back as 2006. That report was called Beyond Scarcity, Power, Poverty, and the Global Water Crisis. And that the conclusion of that report was that it's not about the amount of water, it's about the distribution. And in that context, and related to the key finding from the Cape Town research about equity and fairness, perhaps it's time for us to think about a governance frame in which people all, regardless of their socioeconomic status, their class, their money, that we all are distributed the same amount of water per person, regardless of our ability to pay for more. So thank you very much. I'll leave on that note.
Excellent. Thank you, Jackie. Dina's going to lead the questions part. She's been monitoring the questions in the panel, side panel. Dina?
Thanks very much, Bruce. Thanks to all of you for those incredibly rich and fascinating talks. We've got a few questions. We'll try and get through a couple of them before we're sort of out of time. But Bruce has also shared the links to the papers in the chat, so please have a look at those papers if we don't get to all the questions today, and anyway. So my first question that I have from the chat is for Arkaja. It says, thanks for the nice overview. Was the emphasis that you saw on water as a right to life, or did it also include water as a right to life and livelihood? How was the framing of rights around livelihood aspects of water in the urban service delivery framework articulated?
Shall I answer that?
Yes, please go ahead.
Thanks, Vishwanath, for your question. And, I think there is a specific answer to your question and a more general one. I'll do the general one first, which means it depends, and it depends. Livelihood concerns are in many places an integral part of the way in which, indivisible from the claims around the right to water, for example, around Indigenous people's rights, but in urban contexts also in cases of in the slum eviction cases and in marginal and vulnerable urban populations. So it's in all sorts of places the right to water can be part of. I mean, that's the point that we try to make in our co-authored paper about the decentered construction of global rights. That it depends on the meaning of the right and the sort of the content can shift quite a lot depending on what it is that people are asking for, where they're asking for it, and what is the immediate provocation, or the sort of how that denial of the basic water that they need to live, how that denial has come about. So that's the broad answer. But in India, we're also familiar with the ways in which right to water gets kind of tied up or hyphenated with environmental rights and issues around pollution, which is something we haven't really dealt with we haven't really directly dealt with it in this collection of papers, but it's something that's relevant in many different places and many different contexts. Another sort of kind of joining of issues is the issues which I know you're quite familiar with also, of the issues around sanitation labor, and how that has come to be something that is got sort of read in together with the ways in which people have formulated and conceptualized or reconceptualized the right to sanitation. So yeah, it depends, the answer is that it can depend quite a lot on which venue and which place and what the challenges are and what the opportunities are.
Thanks very much for that question, that answer. I think something that's come up in the chat, although I'm not going to raise the question because there's a good conversation happening in the chat between Inge and Daniela about energy and water and how that sort of maybe changes and influences the sort of understandings we have of right in a climate change moment. Perhaps we have time for one more question in the last minute. This is a question for Namita. The question says, thank you for the extensive presentation of the legal evolution of the right to water in India. How do you see the idea of land, water and forests as a framework with urbanization and a tap in every house approach to water supply as a right? Also, is the frameworking of water as a common pool resource and not a private or state resource maturing at all in the legal understanding of the rights issues?
Thank you, Vishwanath. So there's a lot of questions within your question. I'll try to answer those. So I moved from New Delhi to Sydney and then to Melbourne in Australia this month. It was 47 degrees Celsius in Delhi. It was the hottest summer in over 100 years. And it has been extremely cold in Sydney and in Melbourne, unusually so, a lot of rain, a lot of very bad climatic phenomenon. And essentially what is being realized within, the fact that the bushfires have been so bad and the climatically, there is a growing realization that obviously the way things have been done so far have not been the right way. And so when I say the idea of land, water, and forests, I think that would then, embed itself not just because I don't know what all is captured within the term urbanization. Just like development, it's a term with many meanings. But the idea really is that the way we have been regulating these resources, and that I think goes to your second question, which is, how do we regulate these resources? So within the indigenous imagination, you would not see land, water, and forest separate. So you would not regulate them as separate resources, but rather try to understand the ecosystem and regulate. If you need to regulate, then regulate that as a whole. So to put it into context, we would not have unchecked, unplanned urbanization. We would not have big dams, which have been, shown to be extremely bad for the environment, and also the fact that they displace communities, the indigenous communities in all the countries, actually, because indigenous communities have tended to live in areas that are replete with natural resources, and so dams, mines happen to be in those areas. And we would not pollute those water resources and hold industry not hold industry accountable for destroying the areas within which these communities live and from where the resources are extracted. So in other words, we will not repeat the internal colonization within our countries. So we first had the colonization by Europe of countries in Asia and Africa, and I guess in the US, Canada, Australia, but and in South America, of course. So that was one colonization. Now we are seeing another form of colonization. Even though we are independent from British rule, we find that the resource extractive policies that were part of the colonial states policies have continued, in part also because within the Indian Constitution, we have grandfathered a lot of colonial laws. So for example, our Easements Act, which basically allows you to extract as much groundwater as possible, is a colonial era law. It is from the 1800s, and we still have that law, which has resulted in unchecked extraction of groundwater and water table falling down and huge water scarcity in areas, particularly where there is a lot of farming and there is use for that, but also within urban contexts. So I think we have to rethink and reshape our entire imagination. But mainly the thing that I wanted to bring out in my paper is the fact, and it relates to my other work in the area of land as well, is that these extractive policies that come from a colonial mindset and have been continued in a post-colonial state, post-colonial states, with the same institutional continuities as well. We have, it's not just the laws that have continued, but also the bureaucracy is the same. So the mindset with which it is operating remains the same, because there is historical path dependency, there's historical continuities between that. So really, this is something really radical that we need to do. But I think if we don't do it, there won't be much, much to save in some years. So we have to do it. But that's the kind of radical reimagining that we need. Now, the second thing that you said is every house a tap approach. I think that every human being, something as basic as water, every human being needs to have access to that. Now, I don't know whether it has to be, as Arkaja mentioned at the beginning, it is much better if policies are evolving from the micro to the macro. I mean, different places may have different contingencies. And so I don't know, I never think that a one-size-fits-all approach is the right approach, given the complexity. I think the approach should really be that everyone should have access to a dignified life, dignified existence, to the certain quantity of water that, Jackie has also spoken about, whether it is through a tap in every house or it has to be some other form, I don't know. But I think that's the, like, for example, for people like indigenous communities who may access water from rivers and lakes and so on, I would much rather that we not pollute their water and we not build dams to provide water in every tap to every household, thereby depriving them of their water sources and over a period of time depriving us of our environment, our ecosystem and all of that. So I don't think there is a one-size-fits-all approach here. As regards the frameworking of water as a common pool resource, we have seen the articulation of this common resource idea in environmental law. In any event, the right to water in India was read into part of the right. A lot of the cases are about the right to environment, which was first read into the right to life. And through that, we have the articulation of a common property resource. We also see the articulation of the community resource in the case of land rights. So again, and it's the same sort of articulation that we see, in the sense that it is because, the state. So, and there is a fundamental disconnect here, right? Because the colonial state's imagination, if you look at their laws and their policies, basically they proceeded from the idea that anything which is not privately owned was basically was owned by the state. They could take it whenever they wanted. So they never really recognized common property rights, but the people always had commonly owned resources. So they always claimed that, and that leads to conflict. And as you know, there's been a lot of conflict over land in India. So I definitely see that this idea of common property resources is being articulated more and more by communities and social movements, even the courts to a certain extent, but not always. See, courts do much better with individual cases and individual claims as compared to common property rights. They've done because, and I think that's because of the fact that the nature of the court is that a particular claim goes to the court. Whereas social movements have done social movements have really articulated the commonly owned resources idea, and that is what I've tried to explore in the paper as well, is that to look at different articulations, just like there are different articulations at the national and the international, within the national and the subnational, and within different communities, there are different articulations that we need to recognize, and we perhaps need to see which one sort of whether the mainstream articulation is capturing the needs and aspects of everyone or not. So I think I'll stop there and leave it to others if they want to respond.
Thanks so much, Namita. Thank you. We've had a few more questions, but the panelists have been doing a great job of engaging with those questions in the chat as well, which I really appreciate, because we are sadly out of time. Our next panel starts in 25 minutes. It's on a kind of very different body of water in some ways and body of water rights. It relates to oceans and ocean crimes and fishermen. But we have a lot of panels this week that I think interact in important ways with some of the discussion that's been raised here today, including looking at rights to water and rights to the commons, looking at energy and rights to water. And Daniela asked a question, is going to be part of a panel on Thursday on different water governance systems in different parts of the world, in China and Brazil, including looking at business water use, which I think is a very important dimension of this as well. A huge thank you to our panelists, to Jackie for organizing this panel, to Inga, to Arkaja, to Catalina, to Namita, to Christopher, and to Bruce, who moderated. It's been really fascinating, rich and complex, and luckily recorded, so you can all go back and hear some of the presentations again and read the papers. Bruce has shared the links in the chat, and I think they're on our website as well. And thank you very much to our audience for being here today. Thanks, everyone.
Thank you.
Thank you. Bye.
Thank you. Bye.
Bye.